Okay, there we go. Wow. This is harder than law school.
Karl says that he cannot hear anything, guys. Just FYI.
I can now, Jessica.
Oh.
Okay, we are going live. And we're going live.
So it looks like we are now live on Facebook. So good evening, everyone. Thank you so much for tuning in. This is the second forum in our Know Your Rights series. It is being hosted by the Louisville Bar Association's Public Service Committee, as well as the Charles W. Anderson Jr. Bar Association, formerly known as the Louisville Black Lawyers. We have a fantastic panel here today to discuss criminal law rights. My name is Michelle Duncan, and my colleague, Sarah McKenna, is going to introduce herself. She participated with me in putting together tonight's forum.
Hi, my name is Sarah McKenna. I'm an attorney at Dinsmore and Scholl here in Louisville. I am the chair of the Louisville Bar Association Public Service Committee, and I'm so thrilled to have worked with Michelle and her group on putting together this series on Know Your Rights. For our format this evening, we're going to start with some questions that we've prepared for our panel to kind of lead a discussion regarding the criminal justice system in Jefferson County in particular. And then at the end, we'll have some time for questions from our audience. So if you have questions, feel free to put that in the chat. We are on somewhat of a delay on Facebook Live. So if you post a question, it might take us a little while to get back to it. We may just answer it at the end, but feel free to go ahead and start posting questions there as they come to you. I'm now going to invite each one of our panelists to introduce themselves, starting with Ms. Beets. Ms. Beets, you're still on mute.
Every time. Hi, everyone. My name is Lindsay Beets. I'm a prosecutor at the Jefferson County Attorney's Office. So I'm an assistant county attorney. My boss is Mike O'Connell. He's the elected official. So everything today is my opinion and not his. With that, I am a graduate of Thomas Jefferson Law School in San Diego back in 2013. And prior to working at the county attorney's office, I worked at the Legal Aid Society here in Louisville. So public service has been my career, and I hope to continue in that path.
Thank you, Ms. Beets. Deputy Chavois.
Good evening. I'm Levita Chavis. I'm Deputy Chief of Police of Louisville Metro Police Department, and I have approximately 29 years on. I've been in most of the patrol divisions except for 2, homicide, public integrity, narcotics, street crimes, special events, and I was a hostage team member and a member of the Flex platoon, or actually a supervisor. I presently am over our media and public information office, our administrative bureau, support bureau, and patrol. I'm glad to be here. Thanks for inviting me.
We are so glad to have you. Councilwoman Green.
Thank you so much. Thank you all for the invitation. I'm happy to be here. My name is Jessica Green. I am a 2006 graduate of the University of Kentucky College of Law and graduated from Spelman College in undergrad. I spent almost a decade at the Commonwealth Attorney's Office in Hardin County and also in Jefferson County. I prosecuted everything from child sex crimes to homicides to drug cases. I've been out in private practice now for about, I guess, 7 years. And my practice is revolved around family law, criminal defense, and probate law. I'm also an elected official on Metro Council, and I represented a significant portion of West Louisville and Southwest Louisville. So I'm happy to be here and happy to join such an esteemed panel. Thank you all so much for the invitation.
Thank you. Ms. Beyl?
My name is Chasity Beyl. I am an assistant federal defender at the Western Kentucky Federal Community Defender's Office. I've been in that position for about a year. Prior to that, I took a slight detour into civil practice. I did civil defense litigation with Michelle for about 7 years at Beyl, Stouffer and Graves. Prior to that, I was a public defender at the Louisville Metro Public Defender's Office for 11 years. So now I'm back to my roots and very happy to be doing criminal defense work.
Thank you. And last but certainly not least, Mr. Price.
Thank you. I am happy to be here. My name is Karl Price. I am a practicing attorney here in Louisville, Kentucky since 1991. My past, well, currently I maintain my own private practice, which I've maintained for nearly 30 years. My private practice concentrates for the most part now on civil cases, wrongful death, injuries, serious injuries and wrongful death cases from motor vehicle collisions. I also do some criminal defense work. I'm a former prosecutor with the Jefferson County Attorney's Office, formerly with the Commonwealth's Attorney's Office under the late Ernie Jasmine. In the County Attorney's Office, I prosecuted from almost every division, kind of like Deputy Chief here. I was in almost every division, from child support to domestic violence. I was the chief night traffic court prosecutor. I was the chief firearms prosecutor or backfire prosecutor. And I was the lead arraignment court prosecutor, and I did just general criminal prosecutions for nearly 25 years in the county attorney's office. I'm happy to be here and happy to be a part of this esteemed panel.
Thank you, everyone. Before I start with our first question, I just want to make clear to our audience that today's forum is for information purposes only, so it's not legal advice. Ms. Beets already said that the comments that she makes is for herself only and not speaking on behalf of the Jefferson County Attorney's Office, and I think that goes for all of our panelists as well. The comments that they make today just speaks for themselves. So with that, let's get started. The first question is for Chief Deputy Chavez. I think I know this, but I've learned a lot in this Know Your Rights series. So if you could just start by telling us what's the most common interactions between the public and the police?
Okay, I think I know it too, but then when I look at the data is totally different. One would think that the most common interaction is traffic stops or our traffic stops and pedestrian stops, but it actually is our call for service. We have many different calls for service. We have what we call CIT, which is people with mental challenges, intoxicated persons down, disorderly persons, domestics, and assist EMS. So all of that is together as far as what is our main common call for service are those particular incidents. I know we're here to talk about pedestrian and traffic stops, however, so our traffic stops are probably between those two our most common calls.
So I learned something starting right out of the gate, but go ahead.
Well, I was going to say, just to give you a little bit of background, we've had approximately, in 2019, we had 27,600 approximately traffic stops. Compared to 2020, we had 14,400 traffic stops. And overall, if you take into account our self-initiated and our dispatch runs, 332,658. So traffic stops are just a minuscule amount of the work we do. However, it is the one that you see on the news a lot, traffic stops and
Yeah.
some legal issues.
Wow. Let's talk about traffic stops just because that's what most people are familiar with. And these are very generic questions that Sarah and I came up with, but feel free to expand them as need be. But simply, what should a person do if they're driving down the road and they see flashing lights behind them? Where do they pull over? What would the police expect them to do?
Well, we generally like people to pull over in a safe location, preferably in a lighted location. And I realize sometimes that's hard to do because if it's nighttime out, there might not be a location that's well lighted, but the police car has lights on it itself. And so with the spotlight, but we like you to pull over in a safe location, no curved roads or a road where the road is going upward where you over a hill. So we want you to pull on a straight and preferably level roadway for your protection and for ours as well. So neither one of us get hit. Also, we want you to pull over to the right. A lot of people don't know whether to pull over to the right or pull over to the left or just stop in the middle of the road. But we like for you to pull over to the right. So that's what we'd like you to do when we pull you over, when you see the lights flashing behind you.
Okay, and then follow up to that, I've heard this, I'm not sure if our audience had, that you could perhaps call, I don't know, 911 or the local police station to actually confirm that it's the police that is pulling you over. Let's say it's an unmarked car. Is that true?
That is true. We have unmarked vehicles and we have plainclothes officers sometimes that may make traffic stops. Most of the cars we have now are marked units. However, if you're unsure, whether it's a police officer or not, you can just call 911 and they will confirm with you. One thing we do like to be mindful of is that when the officer comes to the vehicle, he really doesn't want you to be on the car, on your phone, because he doesn't know, it's an officer safety issue. He doesn't know if you're calling for someone or anything like that. So yes, call 911 to confirm if it's an officer. Keep your windows and your doors locked up until you feel comfortable that it is a police officer. And oftentimes they will send more than one officer if necessary, just so you can feel more comfortable.
And I've seen this before. The first thing they asked you is for your license and registration. Should you pull that out before the police officer approaches your car, or should you wait for the police to come and say, I need to get my license and registration, they're in my purse or they're in my glove compartment? How does that work?
People do it all different kinds of ways. Some people have it readily available. Some people have to get it. My best suggestion is to wait until the officer comes up to the vehicle. That way you're not moving around in the vehicle because he doesn't know what you're doing. In your mind, you're getting your registration and your license and things that he'll need, but he doesn't know you and he doesn't know what you're doing moving around. So preferably wait until he comes to the vehicle. When he comes to the vehicle, we have about 6 things that we normally do, and it's actually required in policy. It may not be in that order, but normally we greet the operator of the vehicle and we say, hey, my name's Officer Chavis. I stopped you because you were speeding. And then I may ask you, is there any particular reason why you were speeding? Because you may tell me you were going to the hospital to have a baby. Then that makes sense. And then after I ask you if there's a particular reason why you were speeding, I will tell you why I pulled you over. Because a lot of times people don't understand why they're pulled over. And it begins to be a big confrontation when it doesn't have to be. People want to know the why. So you tell them I pulled you over because you were speeding. And then I'm going to ask you for your license, your registration, and your proof of insurance. Those are the things I'm going to do. I'm going to give you instructions on what you need to do. So preferably just wait until I give you instructions before you do anything.
Okay. And then I think my final question, at least for this round, is should the car be turned off? If you're driving and you get pulled over, do you pull over and turn the vehicle off, or do you leave it running?
You just pull over to the side, you leave it running, you don't turn it off. I always say you don't make any furtive or quick movements. And what I mean by that is you don't just move around in the car looking for stuff or any slow moving movements, because slow or fast, the officer does not know what you're doing. The best thing to do is have your hands visible to where the officer can see them. You don't need to turn on the light because usually they'll either have a flashlight if it's nighttime or they'll have a spotlight. So you don't want to make any quick movements. You don't want to make any movements that are kind of suspicious or anything like that. And so just put your hands where where the officer can see them, whether it's on the steering wheel or whether it's just on the dashboard, and just wait for the officer's instructions and they'll tell you what to do, or they'll request you to do what they need you to do.
Thank you.
You're welcome.
I think Sarah has our next question.
All right. Miss Beyl, what if a police officer during a traffic stop asked to search your car? What should you do?
Well, I'm going to preface this all with, I'm looking at this from a defense attorney standpoint. In my experience, if an officer is asking to search your car, then they don't have reasonable suspicion or probable cause to search it. If they had a reason to search it, they would already be searching the car. So my answer to that is simple. If an officer asks to search the car, say no. Because once you consent, they're going to have access to that entire car. Looking at it on down the road, if there happened to be illegal contraband, then if we were trying to get that suppressed, it'd be very difficult to get it suppressed because you consented to the search. There are ways to challenge it, but it's very difficult. Showing, for example, that the individual was under duress or that there was undue influence. But again, it's very hard to challenge that when you said, yes, you can search my vehicle. I know that it's very difficult for individuals a lot of times because you do have an officer there. Or sometimes it's multiple officers there and they have this show of authority that you feel like you need to consent. And sometimes statements are made to the individual, just go ahead, let us search the vehicle. It's going to make our job easier, and it's kind of couched in a way that the individual thinks that, if I let them search the vehicle, then I can be on my merry way and it's not going to hurt me in the end. Most of the time what I see, it does not help them. So, as far as knowing your rights, you have the right to say no. And my advice is that you should always say no to a consent to search the vehicle.
Is that the same for, if an officer asks you to exit the vehicle or if an officer asks you to take a breathalyzer test?
It's a little bit different when it comes to the officer asking you to exit the vehicle. There are a couple of United States Supreme Court cases that do give the officer the authority to have you exit the vehicle for officer safety. Those cases actually cite to the fact that, traffic stops can be very dangerous situations for officers. And so because of that, an individual can be asked to get out of the vehicle and they can also be patted down to make sure that they don't have any weapons on them that could harm the officer. So, in that instance, you could say, no, I'm not getting out. But in the end, you're going to get out because I think the officer, again, has authority to do that. They have the right to do that. On the flip side of it, you were talking about breathalyzers. That's a different story. You do not have to consent to a breathalyzer. And I look at that the same way as a consent to search the vehicle. From a legal standpoint, looking on down the road, if you do get charged with the DUI, you are better off, in my opinion, not consenting to the breathalyzer because that's just additional evidence that they can, use against you. But in Kentucky, and I will say I'm licensed in Kentucky. I don't know what the other laws in other states are, but in Kentucky, if you refuse to consent to the breathalyzer, then you can end up having a pretrial suspension of your license. So there are penalties under the law for refusing to consent. But I think from a defense standpoint, it's better for you if it's your first DUI, not to submit to the breathalyzer test.
Thank you so much. And let me remind our panelists.
Can I just, one
Yeah, go ahead,
question,
Michelle.
Beyl, because you said, and everybody or most people are attorneys, at least on the panel. So when you said a pretrial suspension of your license, if you could just clarify what that is for our audience, make sure everybody's on the same page.
All right. So usually with the DUI, there is under the law 30-day license suspension if you plead guilty to it. What the law allows the court to do is they can take, the judge can take your license at arraignment. So whenever you go in, I know that we're going to talk about this later about the criminal process, but when you go in for pretty much your first appearance where you're entering a plea of not guilty at arraignment, or guilty, depending on the circumstances. At that point in time, the court can take your license. So that is the penalty that comes along with it. If you do decide that you're not going to consent to the breathalyzer.
And then Councilwoman Green and Mr. Price, the question for you guys is, what about a passenger in a vehicle that is that has been pulled over by the police? Is the passenger free to leave?
You're not free to leave unless the officer says that you're free to leave. And typically what will happen in most of these cases is somewhat of a shakedown. If there are drugs that are found in the vehicle, they can charge the passenger as well if you say that it's in a common area or in an area that the passenger could have control of, which essentially is the entire car. And so in most cases that I've seen where there are drugs in a vehicle, they will end up charging everybody in the car, trying to get somebody to flip on the other person. And so typically an officer is not going to say to a passenger, oh, hey, Mr. Passenger, I believe that you're definitely nothing but an innocent passenger. Call somebody to come pick you up. They're going to essentially put you in custody as well. They're going to interrogate you. They're going to ask you whether or not that they can search your body. They may even ask you whether or not they can search the vehicle. And so typically passengers are as culpable under the law as much as the driver is. That's my experience. Karl, you have anything else different?
You're on mute.
Oh, yeah. I don't really have anything different other than I thought about an example. Two people are driving down the street and they get stopped by the police, and the driver is taking the passenger to work, and the passenger is almost late, and the passenger's job site is about a block away, and the passenger says to the police officer, he's taking me to work, I'm just going, I need to get to work, I'm just a block away. I give that example to just point out that even under those circumstances, you're under the control of the police officer. And if the police officer says that you're not free to leave at that point, then you're not free to leave. And you have to understand that the reason you're not free to leave is because there's a reason that the police officer pulled you over. And the police officer has an opportunity and is given the right and the opportunity to finish his or her investigation, whatever that was. It could be directed at the passenger, and that's one of the reasons why we don't know until actually it all plays itself out. So that's all I would add.
I would like to challenge that a little bit. I think I have seen it both ways, as Councilwoman Green has said, and I've seen it also the other way where the officer has asked from that point.
My clients never get any of the luck, so
Sorry about that.
Thank you for chiming in on that. And just a reminder to the panelists, you guys can chime in on any of these questions if you have things to add, even though we're directing them to people for the ease of the virtual format. So Mr. Price, turning to you, can you chat with us a little bit about the pedestrian stop and what someone should do if they're, walking down the street and stopped by an officer?
If someone is, yeah, sure. If someone's walking down the street and they're stopped by a police officer, again, understand that my responses are premised on one thing. That is that, unfortunately, generally on the street, outside of the courtroom, when it comes to criminal justice matters, the police officer is the judge, the jury, and the executioner. Okay, so you really, and as bad as that sounds, unfortunately, that's true. You know, a police officer can take your liberty away quicker than a judge can in a courtroom, right? So, and particularly on the street. So, if you're approached by a police officer as a pedestrian walking on, you know, walking down the street, my suggestion would be just to simply allow the police officer to inquire, investigate, and execute whatever the reason was he or she approached you on the street. And you know, my best advice, the best advice that I would give to my clients is go through that circumstance. What, you know, because the only way you're going to know whether your rights have been violated is on the back end. Because if the police officer has for instance, if the police officer has a reasonable suspicion to approach you, you know, that's going to be held up in court. And obviously a police officer cannot approach you if you're Black and you're just standing on the corner at 10 o'clock at night. You know, that's not allowed. If you're a young white male and your pants are sagging and you just happen to be hanging outside of a liquor store, police just cannot stop. But you don't know that at the front end. So challenging the police officer's ability to stop you will get you nowhere, because again, he or she is the judge, jury, and executioner out there on the street. My suggestion would be to just simply obey and then come talk to a lawyer, a good lawyer, about testing it on the back end to see if because if you get to the end of this encounter and realizes, you know, and we're all human. If you get to the end of the encounter and feel something in your gut like that wasn't right, it probably wasn't right. Right? It probably was inappropriate for the police officer to approach and stop. But you don't know that on the front end. And that's where a lot of these confrontations come, on the front end, because you're challenging the authority of the police officer, which in my opinion, you should never do, because you really have no idea where that police officer is going and what is in his or her head as to why you were approached. The only way you're going to know it was really bad is when you get that feeling in your gut on the back end. And then you should talk to a civil rights attorney.
So what if the officer asks to search your person? Do you have a right to tell him no?
I think you have a right to tell him no. But again, it really depends on the circumstances. It really depends. It always depends on the circumstances. If a police officer just pulls up to you, gets out of his or her car and says, I want to search you, you know, that obviously is inappropriate. I would assume and I would hope that a police officer would give some dialogue before just simply walking up to someone and saying, I want to search you. A dialogue such as, you know, the woman down the street says that her purse was snatched and the individual was a Black male with a white t-shirt on and blue jeans with a hole right there, you know, below the right knee. And it fits that description. That's probably fair game for an inquiry. But I'm not sure if it gets necessarily to the search, because of course it depends on what the individual who is approached says, you know, how he responds. You know, if he responds in a manner that says, you know, I'm with this dance group and we're all dressed like this, you know, I just came from the dance studio, you know, then that, you know, so it's all about the circumstances.
Can you leave or walk away?
According to the United States Constitution, probably can. According to the case law, it really just depends on the circumstances. You know, and I don't want anybody to misunderstand me. There are many instances, more than any of us can talk about tonight, where you can tell a police officer no, you know. But again, from my lens, it always depends on the circumstances. And I think, you know, particularly Ms. Beyl, because I know she was a public defender when I was a prosecutor, and now she's back in the game in the federal arena. You know, you know, the test in court a lot of times is the reasonableness on the part of the police officer. And when I was leaving the prosecutor's office, because the courts are becoming a lot more conservative, particularly the federal courts, it was getting more and more on the side of the subjectiveness of the police officer, more so than objectiveness. When I was in law school, it was all about, there was some room for objectiveness, and which means what would anybody else do? What would a reasonable police officer do under these circumstances? But I think a lot of times you see I think lately you've seen the case law, and I can be corrected by Ms. Beyl or anyone else, or Lindsay, you see the pendulum sort of swinging towards a more subjectiveness. So, yeah, so.
Thank you so much for that. Ms. Beyl, the past two questions that we've talked about, both talking about a traffic stop and the ability to leave, and the pedestrian stop and the ability to leave, have kind of hinted at this question of being detained and arrested. Can you kind of describe for our audience what it means to be arrested or be detained and what the difference is?
Sure. And before I do that, though, I do want to piggyback on something that Karl said, where he was talking about it is dependent upon the circumstances, about, the reasonableness of the officer and the subjective versus objective. One of the things that really changed from the time that I left the state PD's office to now that I'm back in the federal defender's office is the use of body cam videos. The body cam videos and even people's cell phone footage has made all the difference in the world to me, as far as being able to examine those situations, on the back end, as Karl kept referring to it. So, I think that is something that is important, and we're seeing more and more with citizens is using their videos on their phone, because body cams are not always in play. But it speaks volumes, and it helps tremendously in court when we've got these videos, so that we can see actually what went down in order to make these determinations from the legal perspective. But I just wanted to add that to his comments. As far as your question is concerned about the difference between when someone is detained versus when they are under arrest, it is really a distinction without a difference when it comes to your rights. When you're detained and when you're under arrest, you're basically in custody. So when it comes to, your rights as far as the officer searching you, if you are detained or whether you're arrested, they can still pat you down. They can pat you down to see if you have weapons. And if they feel any type of contraband or, something they think could be, drugs or drug paraphernalia, they can be reaching in your pockets and they can get that. And that doesn't matter whether you're detained or whether you're under arrest. The same goes for Miranda rights. And I know that Ms. Beets is going to talk about this in a minute, but if you're detained, you're considered to be in custody. You're not free to leave. And if you're arrested, you're obviously not free to leave. And so you have the right not to answer questions, and you have the right to be Mirandized at that point. I think that the case law is pretty clear on that. So, when it comes to your rights, I don't think that there is a difference. If you're being held, if you're in custody, if you're not free to leave, you've got those Miranda rights. And, the officers on the flip side also have the same right to search your person, even as if you were under arrest.
Ms. Beyl, I have a follow-up question before we get to Ms. Beets' question, which is, you mentioned that cell phone video has made a world of difference. I think everybody who's watching the news these days sees cell phone videos of various incidents or interactions between citizens and the police. But my question is, it piggybacks on the discussion we had earlier about keeping your hands where the police can see them and no sudden movements, fast or slow. When are we taking out cell phones to record any interaction? Earlier, we used the example of a traffic stop where you're driving and you get pulled over. I presume, and you'll tell us whether you can pull out your cell phone before the officer approaches. But once I think you're engaged in communication with a law officer, I don't know that you have an opportunity to pull out your phone, especially if we're going with no sudden movements.
I have clients doing it all the time, and it's done. I see it with stopping them on the street. I'll give you an example. I actually had a suppression hearing in federal court, and I was lucky enough to win that suppression hearing. It was mainly based upon the body cam videos, but my client, the issue came up, and this is what we're seeing a lot with these traffic stops. And I think it's some of the stuff that we're seeing on the news, as a matter of fact, where officers are pulling individuals over for traffic offenses. And they can pull an individual over for a traffic offense. They can do a pretextual stop. They may have, some feeling that this guy might have some guns or drugs in his car, and they can say, I'm just pulling you over for a traffic offense. But I think that Jessica kind of was talking about this a little bit. And, you can investigate the traffic stop. You can go up and you can ask for license and registration and insurance, but you can't prolong that stop, and you can't keep it going in order to investigate other purposes when you don't have reasonable suspicion and you don't have probable cause to do so. In this particular case that I'm talking about, they were sitting there holding my client. My client and his brother and his cousin were pulled over for not wearing seatbelts. Instead of just citing them, they kept them sitting in a car for 10 to 12 minutes while they're running records, and they're going in, they're trying to get consent from these guys to search the car. They're refusing to give consent. And so what does my client do? My client pulls out his cell phone and he is videotaping everything that's going on. Luckily, I had body cam videos that were also showing everything that was going on. But those body cam videos and those cell phone videos from my client, and I mean, he was videotaping this for a good, I would say, 10 to 12 minutes. It was invaluable evidence that ended up getting the evidence suppressed, because I hate to say this, but I actually had a federal judge rule that my officer was lying about what happened and the reason for searching the vehicle. I mean, we've actually got an opinion that says that, and it was because of the cell phone video, and it was because of the body cam video. But I have found that when an individual is sitting in a car, after you get pulled over, they're asking for license and registration. I've had guys whip out the camera, and I've not had any issues with any furtive movements or, the officer trying to say that, they weren't reaching for a weapon or anything like that, because most people have their cell phones sitting there on the console. But I've not seen that be an issue. And I've seen people use their cell phone cameras, and they've come in to be very valuable in cases.
Thank you.
Can I clarify some things?
Of course.
Okay. First of all, I do not have a problem with cameras and body cameras. I think they're great. I think if you know what you're doing and you know the law, then you shouldn't be ashamed or scared that a body camera is on. So I will say that first. But secondly, one of the reasons why I just want to clarify as far as not pulling out your cell phone to video, and you can do that. You do have a right to do that. But when you're pulling out your phone, me as an officer, first of all, I don't know that's your phone. I might not be able to see that good. So I don't know that's your phone. It could be a weapon. I don't know. And also, you could be calling someone to come, to help you or something against me. So it's an officer safety issue, at least from my perspective. And it's not trying to take anybody's rights of you can't videotape this stop, or I'm trying to hide something. For me personally, and a lot of officers, I would say it's an officer safety issue.
Now, let me just make one. Oh, go ahead, Lindsay.
Thank you, Karl. I was going to say, from a prosecutorial standpoint, if I'm watching an officer's body camera footage and I see that the criminal defendant or someone else in their car, or even an innocent bystander, gets their cell phone out, I want to see that too from the government's perspective, because I wasn't there when this event occurred. I want to be fair to all parties, and I want to have all of the information available. So if there is another video out there from a bystander, taking video of this interaction between an individual and the police, we want to see that as well. So that's my comment to the video.
And I like to add, part of the frustrating part as an elected official is that we have equipped LMPD with body cams, but so many instances, they don't have them on, they don't have them turned on for whatever reason. We know the most recent case with Breonna Taylor. It would have been very useful to have those body cams on. I think that it's unfortunate that even with the city having invested in equipping the department with body cams, that to protect themselves, the citizenry has to really take on the burden of trying to whip out their body cam and hope that an officer is not going to be shocked or think that they're moving for a weapon or a gun. So it's a very unfair burden that I think that a potential defendant has to be able to try to record an interaction when the officers are already equipped with body cams, and all they really need to do is just flip the switch and turn them on.
I've got a quick comment just about the videos also. First and foremost, I think it should be for LMPD, and hopefully this was written into the new FOP contract, that it should be a terminable offense when you don't have, when you don't turn these body cameras on. Because one thing that we have, and to your point, Jessica, I would say that I don't think that it's an obligation of a defendant to feel obligated to videotape, but I would tell you, it has been extremely helpful. I think we can all agree that here in America for the last 5 years, and sometimes beyond, that the truth is always in the video. So, I mean, the truth is always in the video. Where do you want to start? You want to start with George Floyd? You want to start with Arbery? You want to start with Breonna Taylor? You want to start with, where was the last case? I mean, the case in Denver with the young kid that had his face covered, and the violin player, you know. So the point is that video is extremely relevant, it's extremely important, and it is highly evidentiary for us as lawyers in court. I actually have a buddy who files a lot of civil rights cases here locally, and he showed me a case where, you know, basically a young man had a camera stuffed in his car somewhere. It really wasn't a camera, because, you know, with today's technology, you can get these things like James Bond used to get them back in the 60s, right? Very, very small and very, very compact. But I think it's extremely important that, even though you're not required as a defendant to videotape, but it's very valuable if you can, because unfortunately we have learned, and definitely we've learned in 2020, that the truth is really in the video. And that's why I made that statement earlier, that I think it should be a terminable offense. Here in Louisville, when the taxpayers pay so much to finance these body cameras, and then you go out and you know, some officers actually don't have them on. But if you believe that the truth is in the video, then you know, take advantage of the opportunity to do it. And I can tell you, there are cameras everywhere. I picked up 2 cameras that I didn't even need at Home Depot the other night, and my son was saying, "Well, why do you have these cameras in here? Are you going to be watching when you're not here?" And I said, "No, you know, I just picked them up because they were compact, but they have a USB, you know, so I can put them in my car and do that." And it's a shame to think that we feel that you ought to feel obligated to do that, but unfortunately, sometimes the truth is not in the statement when the press conference is given by some police departments, not just here in Louisville, but all across the country. But some police departments, they give a statement about an encounter, and then all of a sudden the video pops up, and then you realize, okay, didn't really happen that way. So that's my point on the videos.
Well,
And no, that's not in the new police contract.
Hold
Not in the SOP
on,
either.
Jessica. Officer Chavez has a comment, and then we'll go to Jessica.
Okay, I just wanted to push back on that a little bit. I do agree with you that the truth is in the video, but it is not always to the negative to the officer. I know several of the cases that you mentioned was adverse to the officers, but the truth has been in the video as well that has supported an officer using force, or in other instances as well. So I like to be more fair about that. And as far as you know, the hands are what can hurt me, is what can hurt me. So that's what I'm looking for. I'm not concerned about whether someone's videoing me if I'm doing what I'm supposed to be doing, and I am, but I'm concerned about the hands that can hurt me. And so that's when I talk about cell phones and being in your hands and videoing, that's the only thing I'm concerned about, is safety.
Go ahead, Jessica.
All I was going to say is, to Karl's point, no, that was not in the new contract. It's also not in the SOP either, and the standard operating procedures either.
And can I just kind of bring it around to since I started this, I think that, again, it's not an obligation of the citizen, but, you know, since we are discussing know your rights, you do have a right to videotape. the interaction with you and the officer. I think that because there is a concern for officer safety, if I think the best course would be, officer, I am getting my cell phone out. I am, going to videotape this encounter. So I think as long as you're being careful with what you're saying and what you're doing, I think that's just fine. But, going to, what we're discussing here in this forum is you have a right to videotape it.
Thank you guys for that robust discussion. So Miss Beets, I think a lot of us have seen on TV when someone's arrested and they're Mirandized, that's what we call it as lawyers and people in the industry, right? But it's you have the right to remain silent, you have the right to ask for an attorney, and that whole spiel that officers give. Can you walk our audience through what that means and how it works? And then maybe if you can, we have a question from the audience about probable cause. And if you want to answer that question as well, that'd be helpful.
Sure. So Miranda Rights. There's a United States Supreme Court case called Miranda v. Arizona from 1966. And what it says is that if there's a custodial interrogation, so you are under arrest, you are in custody, and you're being interrogated or just simply even asked questions by a law enforcement officer, that you have certain rights that you need to be aware of. First and foremost, you have the right to remain silent, which means you don't have to answer any of their questions if you don't want to. You have the right to an attorney. I'm going out of order, sorry. You have the right to an attorney for any criminal charge that in Kentucky, well, you have the right to an attorney to be present for all questions. And then if you can't afford an attorney, here in the United States of America, an attorney can be appointed for you. So Ms. Beyl is part of the Federal Defenders Program, but here in Louisville, we have the Louisville Metro Public Defenders. And in Kentucky, we have the Department of Public Advocacy. So if you are charged with a crime that carries a penalty of a $500 fine or more and any jail time, and you are unable to afford an attorney, the court can appoint one for you. So if you have a speeding ticket and you can't afford a lawyer, that's not something that rises to the level of a court-appointed attorney. You can seek out private counsel or address that on your own. And then with the right to remain silent, anything you do say can and will be used against you. So adding to our discussion about body camera footage, we watch all of those as prosecutors, and any statements that you make after you're given your rights, we can bring that back up in court. I always make a lot of jokes that I like to bring up old stuff to people. And so we will continue to bring that back up. And then, let's see. The goal with the Miranda v. Arizona is that you had these rights in a criminal courtroom setting already, but you have these rights no matter where you are in this world or in the United States. And so it brought the rights for your interactions with police and custodial interrogations outside of the courtroom. And so jumping into probable cause, we've talked a lot about stops and whether or not that was reasonable. An officer has to have probable cause to move forward with a charge and pursuing, that criminal charge against you. So I'm sure Ms. Green and Mr. Price, Ms. Beyl would like to add more to that.
Well, any takers that want to add more to Ms. Beets' summary of Miranda rights before we move to the next question?
I don't have anything else to add.
Well, look at that, silence across the board. So my next question, or our next question, is for Councilwoman Green. I think most people recognize that encounters with the police can be stressful on, I kind of don't like this phrase right now, but both sides, the officer doesn't know what to expect. So they're anticipating things, the person pulled over or the person stopped or whatever is the reason for the police encounter. They don't know necessarily what to expect either. So how would you suggest a person reduce the risk to himself or herself during a police encounter? And just to keep it 100% candid, especially in today's climate, I think it's a fair assessment to say there are some minorities that feel that the stress on their side when interacting with the police is much different than people who are not minorities. So if you could speak to that.
Yeah, I think that, unless you have lived a life where you have walked in Black skin, or unless you have probably represented, like Chasity has, Black defendants who often feel like they are treated differently, you may not understand that some people would say that the justice system is just us against them. And so the reality of the situation is, when you talk about how to take the stress off of the individual who's being pulled over, I'm not really aware of one concrete way to do that. I think one of the things that we have to do is to actively work to take the stress off of the officer and to train them well, and to make sure that they have interactions with people of color that's not just in a situation where you're seeing the bad guy and pulling somebody over for dope. So things that the city is doing moving forward to try to encourage officers to live in certain neighborhoods, like a 40211 zip code, which I represent. Things like true community policing, things like inundating these people with making them go to places so that they know how to talk to people and so that they know how to deal with people. Because, no shade, but if you live in a very rural county, which many of our officers actually do, many of them do not even reside in Jefferson County. So if you're living in a county that is 98% white and you're policing the 2nd Division, which is where I live, which is 98% Black, your interactions and how you interface with people of color is not going to be great. So the way that we start is that we start on the training for the officers, because they're the ones who are trained to, and the burden should be on them, not the citizenry to have to somehow train themselves. But I tell people often, I've got a son that's getting ready to be 17 years old tomorrow, a Black son. And the way that I have to talk to him about potential interactions with police officers is completely different. My white friends and the peers of my kids, their parents, their minds are blown. I've even got an 11-year-old son. I've had to talk to him about interactions with police officers, and his friends' parents' minds are blown that I have to have these conversations with my Black sons right now. And so when we talk about taking the stress off of somebody who's being pulled over, unfortunately, Michelle, I don't really know how we do that, particularly in this climate. I think that what would go a long way is us as a country, us as a state, us as a city, promoting transparency, promoting officers being held accountable when bad things do happen. Because the only way to build trust in the citizenry for the police department is if we make sure that we have actual good officers. And that's why I'm proud we've got on the agenda on Thursday night the Citizens Review Board that will hopefully have subpoena power, that it will establish the officer of the Inspector General. But in terms of just waving a wand, I don't know how to do that. I will say that my 11-year-old, he wants to be a police officer. The only thing that he wants to do is be a police officer, but that's because he lives in an environment. He comes from a family of relative influence and affluence where I have had the opportunity to have good experiences and surround him with officers. But unfortunately, for most people who look like him, most little black boys, they don't have that option. So I think the first thing that we do, we start on the officer side. And so that will be my recommendation.
I have a follow-up question, but does anyone else have a comment in response to my question? Okay, so here's my follow-up question, because I seen this video fairly recently on social media, and I think the podcast was called Uncomfortable Conversations, but essentially it was a white officer, and his question was, sometimes I pull over, for example, someone for speeding, and as soon as I approach the vehicle, let's say it's a minority, it is, you're only pulling me over because I'm X, right? And so his response was, how do you deal with that situation? Because the encounter is already off to a negative start, because the person or the driver that's being pulled over automatically assume they are only being pulled over because of the color of their skin, when in fact, in the officer's mind, no, you're being pulled over because you were speeding or because of whatever the reason is. Anyone have a comment on that?
I have a comment.
So I'll comment on that, Michelle. So I don't really know.
Jessica, hold on. Officer
Oh, I'm
Chasity.
sorry.
No,
Okay.
she's fine. She spoke first, so let's give it to her, and then we'll go to Councilwoman Green.
I was going to say, I have a comment on that. Of course, the traffic stop is getting off on a bad foot, but I think what we as officers have to understand is people come from a place of hurt. There's a lot of trauma that has gone on in the African-American community. So if those officers, and I know for a fact that we teach the history of policing, how there were slave patrols and how policing started, and that's why there's a lot of tension between the police and the African-American community. But I think we teach de-escalation as well. So what I would suggest for that officer to do, if it was me answering that question, is he needs to slow down, take a breath, and realize that people come from a hurt position. They come from a position of trauma that has occurred in the African-American community. And once you understand that, then you can understand where that misplaced or displaced attitude or anger is coming from. And when I say attitude, I don't mean it as a negative connotation, just that's what they're coming off with. So I think once you realize that it's trauma from the ages that have been passed down, because a lot of people, the young people, they don't know to not like the police. The only way they know not to like the police is because that trauma has been passed down. I had a negative experience. So that is my belief that police are evil. So that's what I'm going to teach you, or that's what you're exposed to. So I think the officer slows down. He understands, and we know that in trauma-informed investigation, he slows down and asks him, hey, what happened to you where you don't like the police? You know, I want to hear your story. And I think that can flip the switch or flip that traffic stop from becoming confrontational to being more of a conversation, an uncomfortable conversation, but a much needed one.
Thank you for that.
Mm-hmm.
Councilwoman.
Yeah, I was gonna say, you know, it's hard for people to just be happy-go-lucky when they're getting pulled over. You know, we had a former chief that essentially and factually had people pulling people over in certain neighborhoods and zip codes for pretextual reasons, just to look for drugs. And I think about the young man, Tayon Lee, who lives in my district, District 1, who was pulled over for a pretextual reason, who was treated inhumanely. And the only reason that the world got to see it is because there was cell phone footage and recordings of it. And so again, it's not just that people are, there's a historical context, and they're historically relationships between Black neighborhoods and police officers has been bad. There are active situations. This happened, I guess, a year and a half ago, 21st century. And this is true 21st century policing. And so I understand the officer's angst, and I hope that the officer would understand why typically the young Black male that he or she is pulling over, excuse my baby in the background, feels the same way. So that's all I have to say. I'm gonna mute myself for this baby so really start showing his behind. Thanks.
All right, Sarah, I think you got the next question.
Yeah. Thank you guys for those comments. That is really insightful and helps us, you know, part of the reason we wanted to do the series was to have some of these conversations and talk about some of these ideas. So I appreciate your all's thought leadership on that. Switching gears a little bit, Ms. Beets talked about the Miranda rights, and one of those rights is the right to an attorney. So Ms. Beyl, Mr. Price, and Councilwoman Green, if you all could share your thoughts as to when you would advise someone to ask for an attorney and what that means, what happens. Because I think some people may feel afraid, if I'm in an interaction with an officer and I say, well, I want an attorney. Now the officer thinks, oh, well, you definitely have something going on, or, it could be incriminating. So I'd like to hear your all's thoughts on what you would tell your clients about that. And then maybe your thoughts on what if you can't. We talked a little bit about the public defenders and their roles and how would that work. So I'll start with Ms. Beyl and then go to Mr. Price and then Councilwoman Green.
Thanks. As far as when to ask for an attorney, I think that if you're at the point and you're being arrested and you're being Mirandized, ask for the attorney. Just like I said, as far as the consent to search the car, say no. That's my number one rule. Number two rule is go ahead, ask for an attorney. Let them take care of it. You are not versed in the law, so you let the people that went to law school for that handle it. No matter what kind of pressure that the officer puts on you, ask for an attorney and keep insisting on that right. Don't talk, ask for an attorney. As far as the appointment of the public defender's office is concerned, the way that it works is you are not officially appointed a public defender until you go to court and you are able to either fill out an affidavit or you answer questions under oath from the court as to your financial status. And you can therefore put evidence forth to the court that you can't afford an attorney, then one will be appointed. There are some emergency situations, however, and the Louisville Metro Public Defender's Office actually has an emergency pager. There is an attorney monitoring that 24 days or 24 hours a day, 7 days a week. At all hours of the night. I used to be on pager duty and you would get pages at 3 a.m. You would have to check it, see what's going on. It wasn't always an emergency. A lot of times it was clients being drunk, wanting to know what time their court date was, but sometimes there was an emergency. And, in those instances, we've had to get up. I've had to, get on the phone with a detective that is trying to question an individual and say, do not talk to him. He has asked for an attorney. I'm the attorney on duty. Do not talk to him. So there is a way to do that before you are even appointed a public defender in order to get an attorney to represent you and make sure that your rights are protected. The federal system, we don't necessarily have that, but in my experience so far, I've had this come up a couple of times where the FBI agents were questioning an individual. The individual wanted an attorney. Luckily, it wasn't 3 a.m. It was in the middle of the day, but we were able to go down there and we were able to talk to the individual and determine whether it was in his best interest to speak with the agents or not. So even though technically a public defender has to be appointed by the court, you can still get access to one when you're sitting in an interview room. When you're being questioned by the police, the magic word is, I want an attorney. An attorney will get there for you if you ask for an attorney.
I agree with everything that Ms. Beyl said. I would add this, that if a police officer asks your name and your ID, then that's it. I wouldn't say anything else, because even as innocent as this sounds, where are you going, where are you coming from, that could possibly be incriminating. That could possibly be incriminating, because you have to understand that police officers are trained in criminal law. They've taken almost just as many, sometimes more criminal law classes than us lawyers. So I name and give them your ID. And if you were my client, I would say, don't say anything more. Now, obviously, there are some things that may be necessary to answer. For instance, if you take this scenario, are you related to, Miss Robinson? Okay. Well, Miss Robinson just called us and was concerned that her son had been in a bad car accident. But that's obvious. But generally, it's the name and the ID. I would also say, don't volunteer any information. Know your rights. Don't volunteer any information to the police officer. I have seen so many of some of my DUI cases that I've defended. I've seen so many detainees, if you will, or individuals who have been arrested on the way to the jail, and they were better than Jerry Springer. I mean, they literally said everything, did everything, and talked about everything. A lot of the sophisticated police officers would just sit there and drive, and some of them will respond back. And it seems like a respond, but sometimes it's kind of a dagger, like, say a little bit more, say a little bit more. So don't volunteer any information when you're in the back of the car. Don't volunteer any information when you get to corrections, because I'm gonna let you in on a secret. When I was a prosecutor in the domestic violence unit, I got more convictions, not from what the police officer told me. I got it all from the jail tapes. So when you call to try when an individual gets arrested and then they call and say, I've been arrested, especially if they call their mother, the first thing the mother is going to say, what happened? 90% of the time, the person on the other end is going to say, what happened? And that's the bait. I know it's coming from your mother. I know it's coming from your girlfriend. I know it's coming from a friend, a best friend that you're calling because you trust he or she to come and get you out of jail, and say, what happened? And then the floodgates open. Oh, and she was arguing with me and I had to hit her. Boom. And then you come to court and your lawyer says, he wasn't even there. And then I put out the jail tape. So I would tell you, believe it or not, when you're in jail and you make that phone call, it tells you 10,000 times that the call has been recorded. Listen, because trust me, when I was a prosecutor and I realized that I had a case that was evidentiary, where the evidence was a little bit challenging, and a lot of the domestic violence case, it was always, he said it happened this way and she said it happened that way. I would just get the jail tape and it would solve 90% of the puzzles that I had in those particular cases. So it's not just what you say to the police officer during the encounter, it's also what you say before you get out of government control.
Councilwoman Green, do you have anything to add?
I disagree. I agree with everything that Chasity and that Karl said. And I just say when a police officer has you detained or has you in custody, they are not your friend. They are not there to help you. If they show up to your house to, because your cat's in the tree, that's when they're to help you. Or they're showing up to talk to your kids' second grade class because they want to be a cop, that's when they're there to help you. If they have you detained, they are asking you questions. They are not there to help you. And typically, if you've been involved in the system before, you may already have an attorney on speed dial. I have clients, my repeat customers, who will call me at 2 or 3 in the morning, and the officer will be kind enough to let them talk. Hey, Jessica, this is Officer so-and-so. I got XYZ person here. They say you're their lawyer and they want to speak to you. And they'll let you call them. The first thing I'll say is, do not speak to them. And like Karl, I was assigned to domestic violence unit as well. And the number of jail calls I've listened to where the defendant would be calling the victim and saying, B, you better not show up to court or I'm a bleep, 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 bleep. Now you got a tampering with a witness charge on top of the assault 1 charge because you hit her with a hot iron on her breast. This is a real case that I'm thinking about. And so please do not talk to your mama, your cousin, anybody on the jail phone calls. Just talk to your lawyer and do not talk to the police officer at all besides your name. And that's it.
Or Jessica, the phone call where, I'm going to say he, because it was more men on the DV side of being perpetrators than there were women. When he says, I'm sorry, I didn't mean to do that. And, and that has always been good evidence. But I would just say, as an extension of that question to one of the moderators, what would happen if you asked for an attorney? And legally, what is supposed to happen? The police officer is supposed to stop any inquiry, period. And again, if the police officer doesn't stop that inquiry, that's stuff on the back end. That's not anything you want to challenge the police officer with. Just deal with it on the back end. But understand, if you don't say anything, it doesn't matter whether the police officers are asking over and over and over and over again. But if something seeps out in some way, then you get it on the back end, either in a suppression hearing or some type of lawsuit.
Just to clarify for our audience, again, just because I don't know if everyone's versed in criminal law, suppression hearing is just a hearing to see if certain evidence will be presented to a jury should the case go to trial, could it be considered. So in layman's terms, it's just to throw out the evidence, if you will. Our next question, and it's for Lindsay. We've sort of talked about different aspects of this, but if you'll just walk us through, once you're arrested, what is the process? I mean, obviously there's bond and an arraignment, but if you could just tell us sort of the basic steps of a case.
Absolutely. So you're in the back of a police cruiser and they're taking you down to Louisville Metro Department of Corrections. What's going to happen next is you're going to be booked into the jail. Before you even enter the jail, you're going to go through a body scanner so that you can't bring contraband into the jail that would harm you, others, anything like that. You'd be surprised what people try to take in their socks, in their pockets, and in their bodies. And so once you are booked and processed into the jail, even if you refuse to give your name, you're never giving them your name, you're Jane Doe. They're going to fingerprint you. If you've never been into the FBI's fingerprints, then you're going to be Jane Doe until we figure out who you are. And then, but if you've ever been there before, we're going to figure out really quickly who you are. You're going to be booked at 6 a.m. There is a phone call where the judge on call is able to review your case quickly and set a bond. We have a cash bond system here in Kentucky. So at that point, some people can be administratively released. Some people have a cash bond set, and then they will see a judge at 9 a.m., hopefully the next morning. Here in Jefferson County, we run arraignment court at the jail in non-COVID times, 6 days a week. So even if you're arrested on Friday night, you'll see a judge Saturday morning. If you're arrested after 1 a.m. and processed later than that on Saturday morning, you won't see a judge until Monday. And then they do take off a few holidays, but we are running arraignment court pretty often so people are seen and heard. With that, you'll have another opportunity for your bond to be addressed. There is a public defender in the room, a prosecutor in the room to formally read you your charges, and a judge. And then every courtroom in Jefferson County is equipped with audio and video equipment. So I believe our defense attorneys on here will tell you, don't say anything. We tell you and remind you often, do not say anything, but people will yell out, I was just there to get my Xbox back. I didn't mean to let that happen. You're like, well, you just gave that away. So after that, you see a judge that Monday morning or at 9 a.m. Jail arraignment. We let people out if we can. We set a cash bond. Your bond is based on your history and whether or not we believe you to be a flight, meaning that we don't think you're going to come back to court based on your history or for some other reason, or if you're a danger. If you're charged with some capital crimes and some other things, it's unlikely that we're going to release you, or they're going to set a really high bond based on the danger and the nature of what occurred. And then after that, here in Kentucky, our criminal offenses are categorized into misdemeanors and felony charges. And so your felony charges are usually go to circuit court, that's the higher court, and your misdemeanor charges and your traffic violations stay in district court where I practice. But most cases come through district court, and we look at felonies, and we're able to determine whether or not it is in fact something that needs to stay a felony. And we say go up to circuit court. They used to be upstairs in the courthouse, but now it's in its whole new building. But we still all nomenclature say it's going upstairs. If in fact you have a felony charge in district court that needs to go to circuit court, you have the right to a felony probable cause hearing. So that's an opportunity for you. If you're in custody, it's 10 days. And then if you're out of custody, you have that opportunity. You have the right to that probable cause hearing within 20 days. And where there would be an opportunity for the officer to present evidence and testimony, whether or not there was probable cause, there was enough to go forward with that charge and move it to circuit court. Otherwise, if you have a misdemeanor or a case that can be addressed in district court, the prosecutor can make you an offer or relay that offer to your attorney. You can consider that offer. You can pass it to consider more evidence. You do have a right to ask for the videos, the wearable video systems that our officers do wear. We can provide those in what lawyers call discovery. That's all of the evidence we can gather for a criminal case. And with that, if the plea agreement's not for you and you want to have a trial, you absolutely have a right to trial. With that, you can have a bench trial just in front of a judge, or you can have a jury trial. Here in Kentucky, a jury trial in circuit court is comprised with 12 jurors, usually an alternate. And then in district court, we have 6 jurors sitting. And then the benefit to a jury trial is that all the jurors have to have a unanimous decision, a unanimous verdict. So they all have to agree on whether or not this crime occurred and you were the one to perpetrate this crime. So, it is the burden of proof is that, the burden is on the prosecution, the defense. You don't have to say anything. I love voir dire. Mr. Price and I had a great voir dire, and he, explains it beautifully to the jurors or to the potential jurors that you can the defense doesn't have to present anything. They have the right to not testify, and you can't hold it against them if they choose not to testify. And it's the prosecution alone that has to prove each and every element of the crime. And so that's kind of an overarching description of Jefferson County Criminal Court. There are some other things that we do. We do have some specialty courts for people in specific situations. We have a drug court, we have a veterans treatment court, we have a mental health court to try to alleviate some and divert some criminal charges for those that need extra services. And then I saw a question in the chat. Does it take so long to release body camera video? Well, as a prosecutor, I have desktop access. I'm pretty lucky, and I can watch it instantly and not live because the officers do have to download the videos, but they do maintain custody and control of those videos. So when I want a copy of the video for someone for their case, I have to request it, and they get 100 requests from 100 prosecutors every single day. So it does take about a month or so for them to get that back to us. And so that is why it does take so long in a criminal case. And then, the media does make requests and that type of thing. And I'm not sure how their process works, but from my prosecutor standpoint, I know that it takes a little while to come back, and that's why.
Thank you for that explanation from the state court system. Ms. Beyl, is it any different in federal court?
Well, generally, it's all the same, but federal court is completely different than state court in many, many ways. It's the same as far as arraignment, going in to get arraigned, having a bond set. I'll talk about that in just a minute. You have a pretrial conference, you decide whether you want to plead or not, or whether you go to trial. That's pretty much the way that they are the same. Everything else is pretty much different. When you are brought in for your first appearance in court, it's called an initial appearance, and it's where the judge will explain to you, and it's the magistrate judge, not the district court judge. The magistrate judge will explain to you what the charges are against you, and will also explain your rights. The case will then be passed for an arraignment date as well as a detention hearing. The one key difference, and this is the first that the defendant will experience a difference between state and federal court, is federal court doesn't per se have a cash bond system. For example, like in state court, you'll get released on your own recognizance, or you could have a $5,000, $10,000 bond set. You don't really have those cash bonds in federal court. You're either detained or you're released. The court looks at the same thing. The judge looks at whether you're a flight risk or whether you are a danger to the community. If the judge determines that you are either of those things, then you are detained. There are certain types of crimes, such as drug cases that carry more than 10 years, crimes against children, or crimes of violence where there is a presumption that you will be detained. And as a defendant, you have to overcome that presumption. So you actually have to put evidence forward to talk the judge into letting you out of custody. You then, if you are detained or released, a pretrial date is set and then a trial date is set. I have found in my experience that going through federal court is much quicker than going through state court. There is a Fast and Speedy Trial Act that it mandates that the case be tried within 70 days. It's rarely ever tried within 70 days, but it is fairly quick. For example, the last trial I had was in February. My client had been indicted in July. So we went from July until February, and that's how quickly his case was tried, which is much, much faster than what I experienced in the state system. The other big difference in a federal court that I have found versus state court is discovery. The federal criminal rules do not require the United States to turn over the amount of discovery or the evidence against you as they do in state court. One thing that I found absolutely mind-blowing whenever I started practicing in federal court is if there are witnesses that give statements against you, you don't get those witness statements until after the person has testified at trial. So that means that you are not going to know what evidence is against you until you actually get to trial. And you could be facing, 25, 30 years in prison, and you're not knowing what the evidence is until the individual testifies. So that's a little bit scary and very much different than state court, where that information has to be turned over. Federal court does not have parole like they do in state court. One of the other things that I find that is lacking that Lindsay was discussing is, while we do have veterans court, we don't have mental health court. That's for individuals that suffer from mental illness. And so they are put into a special docket because there is an understanding that that mental illness contributed to their crimes. We do not have that in federal court, unfortunately. We also don't have drug court. And as we know, drugs are a huge problem, and it is the source of many, many crimes. And it is the reason that a majority of my clients are in federal court. So we don't have that, unfortunately, to provide to our clients as an alternative to serve in prison sentences. Finally, I'm not going to get into it because it's too much to discuss. We have the sentencing guidelines where it's a formulaic approach where they look at your criminal history and they look at the facts of your case. And we literally look at a chart and come down and meet in the middle to determine where, how many months that you're looking at as far as the guidelines are concerned. So that's a whole nother animal that is not something that you have in state court, but those are the key differences that I can think of off the top of my head.
So I think today's panel has been excellent. I am very thankful for every panelist's time. This was voluntary, everybody. Sarah and I just started reaching out to the different companies and people that we knew or we knew someone else, hoping that people would volunteer their time and participate in today's panel. I think it's been very informative. We're getting to the end of our time, so I just wanted to ask our panelists for final comments, and Sarah and I will look at the chat feature. I know there's a 20-second delay between our panel and Facebook to see if there's any final questions that we could squeeze in and get answered. But we'll start with Ms. Beets, if you'll provide us with your final comments, and then if we see a question pop up, we'll get that answered before we wrap up.
Well, my sentiment would be you definitely want a lawyer to help you assert your rights. You do have a lot. You have a lot under the Constitution. We didn't even get to talk about that, and I'm a huge Constitution nerd. But you have the Sixth Amendment right against confrontation clause to confront witnesses against you. You have the Fifth Amendment right not to incriminate yourself, and so many more. So with that, you definitely, anytime you're charged with a crime, to your advantage, use the services of an attorney to assist you. I'm a prosecutor. I'm not here to seek, injustice. I'm not here to try to put you in jail, but that is my job. So I want to do it properly, and I want you to get there. I want to do things the correct way, and need you to assert your rights and get yourself a lawyer.
Deputy Chief Chavez, any final comments?
Yes, I don't think we're very far apart. You know, when we talk about knowing your rights, you have a right for us to give you respect, and for us to have equitable interactions with you, and for us to be fair and just. And so with that said, we have a right to also, you all to give us an opportunity to rebuild the trust. And, you know, I really want to do things right. And I think the majority of police officers do as well. So if there's something I want you to know, it would be that just give us an opportunity to rebuild the trust and get your support by doing what's right in a fair and equitable way.
Thank you. Mr. Price.
Okay, the only thing that my last remark would be this, that if you're in the criminal justice system and you're charged with the crime, engage your attorney, make your attorney do his or her job. I have seen so many cases where I've been on the next case for an individual, and there have been motions to revoke. And I tried to explain to the individuals, you know, you're on probation. Oh, I didn't know I was on probation. You know, your lawyer works for you. You don't work for your lawyer. So you really have to keep that in mind, and you know, ask all the right questions. If you don't understand something that the judge said, if you don't understand something that your lawyer is saying, you know, ask that individual to explain that. And when they don't, you have the right to fire them. But you have to leave that that relationship feeling like that you've been represented well, because that's your only impediment, if you will. That's your only security to the other side. The other side may be freedom. The other side may be jail.
Thank you. Ms. Beyl.
I guess my closing statements is this, and I'm getting on my soapbox here a little bit. I have been a public defender for most of my career, and I would leave the public with this knowledge. Public defenders know what they're doing. I know they get a bad rep, but Louisville Metro Public Defenders, I know when I was there, they were considered to be the second top public defender's office in the country. They were considered the supreme public defenders. They do criminal law day in and day out. That's all they know. That's all they do. You know, time and again, judges talk about what fantastic jobs they do. They are the trial attorneys. That's who you see on TV. That's who you see representing individuals. And the same goes for federal court. You know, the public defenders are doing this not because they get paid good money. They're doing it because they love what they do. And, you know, a lot of times I have been asked through my career, when am I going to be a real attorney? They are real attorneys. They actually graduated from law school. But, you know, again, I think there's such a public misconception about it. They do have a lot of cases, but they are very, very good at what they do. And the public, if you are appointed a public defender, you should trust in your public defender.
Thank you.
I totally agree.
Last but not least, Councilwoman Green.
I agree with that, Chasity. I had to call Krishna Tibbs and Courtney Kellner over the weekend on a question that I had. These are former public defenders who are now fancy, rich private counsel, but still people that I look up to and that I will go to ask questions for. My only comment, first of all, thank you guys for the invitation. And my point to the public is the rights that you have are your rights. And so if someone is asking you to waive those rights, don't be pressured to do that, because these are rights guaranteed to you by the Constitution of the United States of America. And so if somebody is asking you to search or asking you to do something, or can I come into your house? Will you let me search your car? They're not asking you that just to be polite. They're asking you that because the law requires them to do that. And so before you just are quick to say, yes, you can, because you think that it's the appropriate and polite answer to do, you should think long and hard about how that may potentially negatively impact yourself. And so officers have a job to do. And so you should make them do their job. And you, as a potential defendant, in my opinion, as a criminal defense attorney, should not help somebody build a case against you. So that's it.
So I think that's it for this evening. But again, Sarah and I really want to give a huge thanks to each and every one of our panelists. I've gotten some feedback from Facebook that the audience thanks you as well for your time. This is actually our second forum. The first one was on voting rights, and this one was criminal law. We are in discussions to do a third one. We really want to talk about social justice, so we hope that everyone will tune in for that one and be on the lookout. Sarah is at Dinsmore. I am at Beyl, Stouffer, and Graves. This panel was presented to you by the Charles W. Anderson Jr. Bar Association, formerly Louisville Black Lawyers Association, as well as the Louisville Bar Association, the Public Service Committee. So that's how you can reach either of us. Again, thank you everyone for your time. Very much appreciated. I think tonight was very informative, and we are just so thankful for you volunteering your time today.
Thank you, guys. Appreciate it.
Bye-bye.
Oh, I had a quick question for Chasity. I have to call her and ask her. I had a question when she said that most of her clients are, on drug cases in the federal system. And I've never practiced